Hi, I'm Dave Hirsch, and I'm a trial lawyer. I try civil cases. Today, we're going to talk about how heavy is the burden of proof. We've previously talked about what it means to have the burden of proof in a civil case. The fact that the party advocating for a position has the burden of proving their position. But the question I often get is, what does that mean? How heavy is the burden of proof? We know that civil cases are not the same as criminal cases, for example. We all know that in a criminal case, the state has the burden of proof, and they must prove each element of the crime, quote, beyond a reasonable doubt. That burden of proof is a heavy burden of proof, and it's rarely used in civil cases. While there are varying degrees of burdens of proof in civil cases, the most common burden of proof in a civil case is by a preponderance of the evidence. By a preponderance of the evidence. So if a civil plaintiff has to prove his or her case by a preponderance of the evidence, well, what exactly does that mean? A preponderance means more than half. Sometimes we think of it as percentages. A preponderance is more than 50%. Does not have to be a lot more than 50%. Certainly it doesn't have to be 100% or 90% or even 75%. It only has to be more than 50%. Maybe an example will help. The Colorado jury instructions say this: to prove something by a preponderance of the evidence means to prove that it is more probably true than not. So a preponderance of the evidence means that the jury decides that the elements of the claim have been proven and they're more probably true than not. That same jury instruction goes on to say, if a party fails to meet the burden of proof as to any claim or defense, or if the evidence weighs so evenly that you're unable to say that there is a preponderance on either side, you must reject that claim or defense. Finally, and this is the last part of the instruction I'll quote for you, the instruction says the party with the burden of proof can use evidence produced by any party to persuade you. And that's really cool, because that means if you're the plaintiff, you can use your evidence or you can use the defendant's evidence. Of course, the defendant can do the same thing. So when a plaintiff goes to court to prove his or her case against the defendant, the plaintiff has to satisfy the burden of proof. He has to satisfy the burden of proof as to each element of the plaintiff's claims, and the plaintiff must prove to the jury that each element of the claim is more probably true than not. Of course, as a trial lawyer, I don't like cases that are just 51% cases. I like to take cases where I can convince the jury that my party is correct, and I do my very best to prove to the jury that my client should win, and I try to make that proof by the largest margin possible. Lawsuits are difficult. They're time-consuming. They're hard. And so when a plaintiff takes on a case, when a plaintiff elects to bring a case to court, the plaintiff will be faced with the burden of proof, and the plaintiff and their lawyer should welcome that burden. And that is basically a description of how heavy the burden of proof is. If you have a legal matter that I can help you with, please feel free to contact me at 303-792-5595. Or you can reach me on the web at Burg Simpson, B-U-R-G, Simpson.com. I'm Dave Hirsch, and I'm a trial lawyer.